Good morning. We want to welcome everyone here for today's session of Appeals on Wheels of the Court of Appeals of Indiana. My name is Scott Lee. I'm an associate professor of political science here at Indiana University East. I'm the chair of the Department of Criminal Justice and Political Science, and I'm also the pre-law advisor. I am always happy to visit with anyone who's interested in law school. We acknowledge and are grateful for the members of the Court of Appeals of Indiana who will be joining us shortly. Currently, they're walking down the hall this way. I just got the high sign. We also want to welcome their staff, our local judges, local and state government officials who are here with us today. We acknowledge each of you, our students, staff, faculty, and members of the community. Thank you all for coming. We also thank the IU East staff that have worked to set everything up for us today. We do have a few spots for a few more students to join us for lunch with the judges after the session is over. If you're interested, please see me right after the court session and I'll get you in. For the students that are coming to the luncheon, it's in the community room across from the den here in this building. Now, before the session starts, let me just remind you of a few housekeeping items. Please, no talking. At the end of the session, there will be a question and answer period, but do not ask any questions about the case that's being argued here today. When the judges enter the auditorium, it becomes, in essence, the courtroom, and the courtroom decorum must be observed. Please be respectful of individuals who have personal involvement in this case. Remember that the parties, their families, and others are people who have been personally affected by these proceedings. Please silence your phones. I've asked the state trooper to not arrest you if yours goes off, but I can't guarantee that. No pictures may be taken and no recording of the session is allowed, with the exception of WCTV, which we acknowledge and thank for being here. The court is also recording this. Please remove your hats to make when the judges enter the room, you will be asked to stand and will remain standing until be told to be seated. Again, welcome to this session of Appeals on Wheels of the Court of Appeals of Indiana.
All right. Hearing. The Court of Appeals of the State of Indiana is now in session. The Honorable Melissa S. May of Vanderburgh County presiding, with the Honorable Leanna K. Weissman of Dearborn County and the Honorable Peter R. Foley of Morgan County. You may be seated.
Good morning. It's good to be back at IU East here in Richmond. We are here in the case of McElhaney, how do you pronounce that? McElhaney versus Jordan. And we have Mr. James Budenbaum. Did I get that right? That's good. For the appellant, you have reserved 5 minutes for rebuttal. Sorry. And then John Mervilde, sorry, and Kevin Lichtenberger.
You got it right.
All right, for counsel for the appellee. All right. Mr. Budenbaum, are you ready to proceed?
Yes.
You may, counsel.
Oops. Thank you for everyone for setting us up, counsel. May it please the court, my name is James Budenbaum. I'm here on behalf of Peggy McElhaney. Peggy McElhaney on February 7th, 2023 was an employee and a, oh, my mic just died. Is this okay?
Yeah, sure.
Okay. Was an employee of Rural King in Avon, Indiana when she was bit on the face by a dog named Gus. The dog was owned by Elizabeth Jordan. We're here before you today because the trial court erred in granting summary judgment in favor of Elizabeth Jordan in this case. There is another party to the case, a defendant, Jacob Grisham, who is as she would describe, a trusted companion and live-in boyfriend of Elizabeth Jordan. We believe that there's sufficient evidence for a jury to weigh and conclude that Elizabeth Jordan knew or should have known that Gus, this dog, had a dangerous propensity. And those pieces of evidence are as follows. First, the adoption papers, when Elizabeth adopted this dog, included notes from the person who captured the dog that it had seriously aggressive behavior during that capture. Number two, when she adopted the dog was already on medication for anxiety to control its behavior.
Trazodone, right?
Pardon?
Trazodone.
Yes, trazodone. Number three, Miss Jordan did admit that this dog was different than other dogs she had adopted.
And she'd adopted a pit bull before, is that correct?
That is correct.
So can we talk a little bit about where Indiana law is on these cases? It seems like we have a bunch of different cases that all turn on the facts. And so what I was able to glean by taking a look at them and trying to synthesize is that we have a presumption that all dogs are harmless, regardless of breed, but that can be overcome by evidence that the owner knew or should have known of dangerous propensities. That could be either through specific prior acts or breed characteristics established by expert testimony or commonly known tendencies. And that would be the ultimate question going to whether the owner exercised reasonable care given what they knew or should have known. Am I getting that correct?
Well, yes, Your Honor, and I would add that I believe that it's not limited to that. Those are the cases that exist. I think if you read some of the other case law, it refers to the tendency of an animal to do an act. And that's an 1890 case.
Does that involve a dog or another animal?
Specific to the dog or that particular animal rather than the breed of the dog, I think also can show a tendency of that dog to be dangerous.
So these are very fact-specific analyses, which is part of your request that this go to a jury.
Yes.
Okay. So how do you apply that framework to the case before us, the framework that I just gave you?
The case before us is a negligence case, and of course I don't have to remind this panel that negligence cases should err on the side of going to trial so that the facts, as you've described this myriad of different kinds of facts, can be heard by a jury, and the jury can weigh those facts. I think in this particular case, you also, and perhaps in other cases, Miss Jordan, as well as her friend Jacob Grissom, are the ones who possess most of the knowledge about this dog. I mean, we have some information that we've been able to glean from documents. She denies, of course, that the dog is dangerous, but she does possess most of the knowledge. And there are reasons that she should be impeached before a jury.
Well, Jordan is the owner, right? I mean,
Yes.
she's the registered owner
She's the owner.
of the dog.
Yes.
And she gave her deposition and she testified about various things that she knew about the dog.
Yes.
When you talk about all the different facts that need to be considered about this, it's not just the fact, with the trazodone or the dog had to go through training. There's also information about what happened to the dog the day before the bite. Is that correct?
Well, it was on the same day of the bite, and I think that confirms some of the other information. When the dog was brought to the Rural King by Jacob Grissom, at least one of the affidavits that's in the record is from Kevin Bray. Kevin Bray said that he met up with them and he was an employee of Rural King as well, met up with them, and at that time the dog snarled, growled, and lunged at him.
Well, isn't it true that the day before the dog's friend Lois, the other pit bull, died?
I believe that is true.
And that on the day that he took the dog to Rural King, he actually dropped off Lois at the vet for cremation with Gus in the car?
I don't know that.
That's what the record seems to indicate. Do you think that might be a certain fact that might, add into the whole how upset the dog might have been?
Well, I don't know that because I don't know that we can get into a dog's mind as to how they react. We can just look at the facts that were available, which includes that on prior occasions, including 1 month before this event, that the dog had nipped at the vet tech at the vet's office and also tried to bite at the vet. And on 2 occasions, the dog had to be muzzled to be treated at the vet's office. So I think, given the medication, given that she believed the dog was different, given that the dog had to be given behavioral training and the muzzling, that I think that Miss Jordan was on notice that this dog, that she knew or should have known that this dog had a dangerous propensity.
Let me ask you.
I'm sorry, go on.
Sure.
How's
Okay.
it?
I'll jump in then. Because Miss Jordan is the one that was subject to the summary judgment motion at issue before us. There are 2 defendants, Miss Jordan and Mr. Grisham, and they cohabitated, but Miss Jordan was listed, I think, or the facts would reveal her as the owner of the dog, she adopted the dog, correct?
Correct.
But she was not present on the day of the bite. Present by that means she didn't have control and custody of the dog at Rural King, correct?
No, she did not.
So if the question, I guess, what's your theory of negligence for Miss Jordan? What did she do? Where was her duty breached with respect to, and I know we're down kind of the train in the analysis from that, but I think it informs us as to how we look at the facts and circumstances and what her knowledge was. What's the allegation of where she was in breach of her duty?
As the owner who adopted the dog, she was aware that and we just discussed all of these potential indications that the dog had a dangerous propensity. I think that taking the dog to a social setting where the dog is forced to interact with humans, I think that that's one of she had a duty not to allow that to occur, and she allowed it. She, in fact, admits that she had taken the dog to some Rural Kings or other retail locations prior to this. And then while asked at her deposition, why did she continue to, how did she feel about him taking the dog? She ratified it. She said she understood and agreed that he could do this.
But then that begs for me, I guess, maybe creating a boundary point that the circumstances that would lead her or a reasonable person in her situation to conclude the dog had dangerous propensities are going to be limited to facts and circumstances that occurred at least up until the moment that Mr. Grisham took the dog to Rural King.
Yeah.
Because then that's our break, right? Because she can't be charged with any knowledge of what happened at Rural King, correct?
No.
Okay.
Indiana used to have a 1 bite rule, so a 1 bite free rule, kind of. That's not really the law anymore, is it?
Well, I'm not sure that ever was the law. I think that was a phrase that people came up with to describe a dangerous propensity of a dog. I don't know that there ever was a 1 bite rule.
So it's not necessary that a dog actually bites somebody before they could be found to have, quote, a dangerous propensity.
Well, I think that they have a dangerous propensity. Now, and I think that's more important in this case where you're taking the dog to a location where other people may be, including, obviously, strangers might be. One of the cases cited by the defendant, Alfano, emphasizes this. It's probably the antithesis of that thought. In that case, the dog was sequestered or maintained inside of a fence, had a beware of dog warning. One child came up, was petting the dog fine. Another child came up and sadly had part of its ear taken off by the dog. I think that's a different situation than this situation and these set of facts. As the court has said, and again, I'm citing an older case, a propensity or tendency of an animal to do any act which might endanger the safety of a person or property in a given situation. So I think that we have to give consideration to what
talk
the
to you a
situation
little bit about the breed of the dog. We have a couple cases here that I'm concerned about making sure that we get them correctly and look at them correctly. So we have the Supreme Court telling us, and I think it's Poznansky, that the presumption is that all dogs are harmless regardless of breed. But then we have another case where we have an expert coming in and saying that the Great Dane dog specifically is a dangerous breed. But then we have another case, Tucker, that seems to draw that line a little farther, where in Tucker, I believe it was a small claims case, and based only on the trial court judge pontificating that pit bulls were generally known to be dangerous, that they were lumped into a dangerous breed. Is Tucker an anomaly? Did Tucker apply the Supreme Court precedent correctly? What are we to make of all that?
No, I think Tucker is not an anomaly. I think Tucker, in the Tucker case, the Court of Appeals affirmed that case, including what the judge said.
With a dissent, over a dissent.
Yeah, the court could have, of course, not affirmed his decision. And what he said is that we don't have to, and I think referring to potential jurors, we don't have to check our common sense and our knowledge of the world at the door when we become jurors. When we become jurors, we go in there and we're supposed to use that common sense and that knowledge, which of course is somewhat.
That's a little tricky though, because if what you're saying, if I'm following your logic correctly, doesn't that create a per se rule that pit bulls are per se dangerous, and therefore always in these cases the owners of pit bulls will be liable?
Well, I think part of it is that they are a fighting dog, but I'm not sure that's in our record. But the thought being that a dog that can perform such vicious injuries so quickly, and I think that's what that judge was saying in that particular case, and that we should take that into consideration. When
But there's nothing in your record regarding breed-specific
No.
evidence. Okay.
And the affidavit of your expert did not have any breed-specific
It
thing.
did not have affidavits breed specific. She reviewed the records concerning this dog, including the taking of the medication, the frequency of taking the medication. She reviewed all of the transcripts from the depositions, and it was her conclusion that it was unreasonable to take this dog to a place where it was forced into a social setting where it might result in it nipping, biting, lunging, and ultimately biting someone, which all, of course, occurred in this case.
There was evidence that the dog was not up to date on its vaccinations at the time of the bite. Isn't that correct?
That's true, and it was as a result of that, it was
It had to be quarantined.
quarantined.
So does that, the duty of care to have your dog vaccinated, obviously there's not an issue here that it actually had rabies or any reason that was to be concerned about. But is that a duty of care that we really should be concerned about? Should we worry about conflating that with the idea of the dangerous propensity?
Well, it may very well go to the way in which Miss Jordan treated her dog and her lackadaisical view as to whether this dog had dangerous propensities based upon all this other information concerning medication, having to be muzzled at the vet's office and those things. I think it, maybe is consistent with that.
Let me ask you this, because I've got one concern, I think, in analyzing this case and whether this dangerous propensity has been established such to rebut the presumption of a harmless dog. Is it your position that any of these things in itself, like just because somebody has a prescription for anti-anxiety meds to their dog, that it leads to the conclusion that we've rebutted the presumption?
No, I think it's the combination of the 4 or 5 things that I talked about, coupled with, of course, the fact that Ms. Jordan and Mr. Grisham are the 2 people who have the most knowledge about it, and I think they should be subject to impeachment before a jury. This is a negligence case, as the court well knows, should err on the side of letting negligence cases go before the court. We're not asking that she be held strictly liable. We're just asking that a jury hear all of these facts and decide on their own as a jury, which is our system that we have, consider whether she should be held liable. And for that reason, we ask that the Court of Appeals reverse that summary judgment.
Thank you, counsel.
Time has elapsed. Thank you.
Yeah, you have your 5 minutes for rebuttal. Counsel, you may proceed.
May it please the court, again, my name is John Rebildy, and I represent Elizabeth Jordan in this appeal. Elizabeth Jordan is a responsible dog owner. She didn't get Gus from a backyard breeder or pick him up off the street. She adopted him from the Indianapolis Animal Shelter. She continued for a time the medication that he was on, that he had been put on at that animal shelter. She took him to the veterinarian regularly. When he was more anxious and active than the other dog that she had, she didn't just let it go. She hired, at a significant expense, a dog trainer to work with her and to give her advice, and she followed that advice.
So she was a responsible dog owner. That's what you said, correct?
Yes.
Does a responsible dog owner allow their vaccinations to lapse?
Well, I would note, first of all, I don't think that fact is relevant to the appeal.
I don't care whether it's relevant or not. You opened the door by saying she was a responsible dog owner. Does a responsible dog owner allow their vaccinations to lapse?
I think that in a case such as this one, where she had taken this dog to the vet about a month prior to this incident, I think that, I'm a dog owner. I can't tell you off the top of my head when my dog's rabies vaccinations expire, but if
Well, I believe it's listed on the paper that they got from the vet, that it says vaccinations were due. So the vet would have said, hey, your vaccinations are due. Oh, let's not do it this time. So she was a responsible dog owner by letting her vaccinations lapse. Was she a responsible dog owner by knowing that her dog was stressed? And that's what she testified to in her deposition. Knowing her dog was stressed in a stressful time, knowing that he'd been anxious with Lois passing, allowing that dog to be taken to a public place with a whole bunch of people around?
Well, I don't think the record shows that she had any role in the decision of Jacob Grisham to take the dog to work.
So are you saying that Jacob Grisham had no authority to take the dog?
No, I'm not saying that. Ultimately,
He did have authority, right? She gave authority to him.
this dog was treated as a household dog, as the family's dog.
Well, you opened the door to responsible dog owner. I'm just questioning you about that.
Oh, certainly. And I think that in addition to adopting him responsibly, in addition to putting him on medication responsibly, in addition to hiring the dog owner and dealing with that responsibly, then ultimately I do think it shows that her behavior as it relates to the dog was responsible. But more to the point of this case, the ultimate question is not whether she did a perfect job with her dog, but whether she had any reason to know or any actual knowledge of a dangerous or vicious propensity such that she could have done anything to prevent what happened to Ms. McElhaney. Obviously, what happened to her is terrible, and everyone wishes that it had not happened. But ultimately, she did not, as the court discussed during Ms. McElhaney's counsel's portion of the argument, and as I believe he conceded, there is no breed-specific evidence in the record that would allow conclusion that Gus is a member of a dangerous breed.
But there are other states that have found that pit bulls are inherently dangerous. Isn't that correct?
As far as I know, we didn't brief it, but Indiana has not.
Right, Indiana has not, but there are other states across the country that have done that.
There are states in other countries.
And there are, in fact, insurance companies and other like homeowners associations that have prohibited pit bulls from being covered under their policies or in their homeowners associations.
Yes, I have no reason to doubt that.
Let me ask you a question. I think your latest comments bring this up. The affidavit of the veterinarian, Dr. Conklin, that's at issue, are part of the record. And it did not mention breed specific. But one element that it does bring up is the dog's confrontation with its fears. It gets to this social setting and the propensity for the dog to be stressed with unfamiliar people. You know, she wrote that owners should never force a dog to confront the fears head on. If a dog is afraid of unfamiliar people, he should not be forced to interact with visitors or be taken to crowded areas. And her position was this dog had shown those propensities to be very uncomfortable and stressed in a social setting. Isn't that sufficient to get to the jury to allow them to weigh and sort through?
I don't think it is in this case because, first of all, what the case law says is not that you can't date an anxious dog in public or that you have to protect against anxious propensities, but it's that it's dangerous and vicious propensities. So I think, first of all, as to Dr. Conklin's affidavit on that point, I don't believe that it creates an issue of material fact, because it's basically Monday morning quarterbacking when we know, based upon Elizabeth Jordan's testimony and on the testimony of Julie Allen, the dog trainer that she hired, that dog trainer had recommended to them that they socialize Gus by taking him into public, including to pet-friendly stores that allow dogs, such as rural canines.
So then, are we going to carry forward with the idea that this presumption is rebutted just through bites, or just through or a similar incident? I mean, going back to the idea of the one bite rule.
Well, I do think that while the one bite rule characterization is probably an oversimplification, I do think that that's the shorthand for what we're talking about, which is whether there is evidence that would require an owner to be on notice of a dangerous or vicious propensity. And I think if you do look at some of the reported cases, including the Alfano case, Wisnansky. So for instance, Wisnansky talks about the difference between a nip on the hand and a full-fledged bite. The Alfano case, I believe it is, which is a Court of Appeals case from 1984, talks about the notion that even lunging against a leash, growling, barking at passersby, those sorts of things don't necessarily put you on notice that the dog is at risk of an unprovoked bite. And I think that's an important aspect of the language that's in there too.
So do I understand you correctly that what you're saying is a lot of what she knew was hindsight? So the behavior of the dog the day at Rural King, as Judge Foley was asking your friend on the other side, it can't be relevant to what she knew about the dog's propensity.
Yes, I definitely, that definitely is our position, that what happened at Rural King cannot affect what Elizabeth Jordan's not.
And the thing that their vet said about the dog is somewhat hindsight. She was operating under the assumption of what her trainer had told her, was that the dog was puppy bitey and should be socialized.
Yes, and I think that the facts that the plaintiff is pointing to really fall into four categories. First is the issue of animal control at the outset, where, yes, he barked at a stranger who was trying to capture him, but the report also says, well, he was a good boy, used some caution, but he called.
And after that, she took the dog to the trainer, actually left the dog with the trainer for a week, and spent about $1,400 on training.
Yes, and she relied upon the advice of the trainer. Well, she didn't have a decision. She was a part of the decision on that day to take him to Rural King, but would not have objected to it because this professional dog trainer advised them to do that with the.
Go on. On the other side of this equation is her having to see the dog being muzzled at the vet. That would be maybe a concern.
Yes.
On the other side, she would have known about the household, about her dog having just lost his friend the day before, and notice some anxiety. So all those the jury may weigh differently, correct?
I think that the issue with the veterinarian, first of all, she did not actually witness it herself. It was Mr. Grisham who was there when.
But she knew about it.
Well, she knew about it, or at least couldn't rule out that she knew about it. But the bottom line is, we've talked about the dog trainer. She really relied, if you look at what all the professionals that were actually involved in Gus's care, not the expert who came in to review it after the fact, you see the animal control folks. I mean, not every dog that is captured by animal control is adopted out. Not every dog that gets to the Indianapolis Animal Shelter is adopted out.
Because sometimes they'll find that they're too dangerous and they'll be euthanized. I mean, that's the sad reality, right?
Certainly. And the vet, the muzzling issue, obviously both of the records concerning when he was muzzled talk about the fact that he had a sensitive left ear, and that seemed to be triggering the issue with trying to nip the veterinarian or the vet tech and having to be muzzled. But on the other hand, it's not as if the vet records show that there's any recommendation to do anything different, don't take this dog out of the house, get him into behavioral training. There's nothing like that in the vet records. So,
Well, the dog trainer described the dog as reactive. And that's a specific word of art in the dog training world, is it not?
It is, and the way that she described it in her deposition was that when she initially met the dog, he was pulling at his leash, barking at her, but that she never saw anything, any bites, attempted bites, growling, snarling at her during the course of that extensive training that she conducted out there.
But a reactive dog can bark and then be reactive as a warning that something else could happen. I believe she testified that she noted that reactive dogs will bark and be reactive as a warning.
Yes.
So let's talk about the cut that was on Gusta's face. There was no real testimony, was there, about how the cut actually occurred, other than Jacob's testimony saying he fell out of the truck?
I think that was, I don't want to say for certain that that's in Jacob's deposition, but I believe it is, and I think it was corroborated by Mr. Braze.
And that was on the left side of the face, the left side of the dog's face.
I believe so.
And the dog was reactive as to the left ear.
That's what the veterinarian said, yes.
Okay.
Well, let me go to the question then, because I think as plaintiff has presented this, at least in response to one of my questions, it's not any of these one individual facts. It's the combination of them. It's not the individual brick, but it's the fact that you stack them and then you end up with a wall. And that is the job of the trier of fact, and not us as a court to make that determination. How do you respond to that? And particularly, there are also kind of the sub point of that the tellers of their knowledge are the people that have that knowledge, right? So we should subject them to credibility stress, for lack of a better word, under cross-examination, and let the jury see whether they are truth tellers or not, whether they can be trusted by their testimony, because they're the gatekeeper of what their knowledge is. No one else is. No one can get in between your ears, my ears, Judge May's ears, and understand what our knowledge is, but these objective facts try to give us clues to that. So how do we wrestle as a court with the idea of this should be the province of the jury, subject to cross-examination, and it's a combination of these factors versus one individual thing?
Well, I still think that even with the combination of factors, I do think it's hindsight to suggest that those show a vicious propensity. I think, again, as noted, the animal control situation was obviously the capture of a stray dog, and even then they called him a good boy. Later in the record, he seemed to think that the dog would be fine. The medication, anxiety medication, that seems like kind of a, heads I win, tails you lose type situation. To me, having anxiety medication is responsible, and it doesn't necessarily, an anxious dog and a dog whose anxiety is being controlled by that medication, to me that doesn't necessarily indicate even any kind of a yellow flag.
But she didn't continue the anxiety medication. It was only for a short time after.
It was for a short time, and she testified that was based upon the advice to acclimate him to their home. And even when he was at the home, she didn't just say, well, this is just going to be a more active dog than I have. She hired a trainer and followed that trainer's advice. She followed the veterinarian's advice, with the exception of the rabies vaccine oversight. So I don't think that any of them, especially when we look at the cases and we look at the facts about these other dogs, and the cases that have been allowed to go forward to trial either have that telltale incident, but we also have indications, as I've discussed before, about the fact that, barking at passersby, lunging, those things don't necessarily get you there. So if you have a few things that don't get you there, I don't think that the fact that we have these 3 or 4 details over about a year that they owned this dog prior to the incident, I don't think that creates an issue of material fact, especially when Elizabeth Jordan wasn't involved in the decision to take him to Rural King on that particular day.
Well, but that's a different analysis. That's analysis of whether she breached her duty, which is downstream from the threshold decision of whether this presumption has been rebutted that it's a harmless dog.
Certainly, and I think that, but I do think it comes into play if we're talking about what Elizabeth Jordan knew at the moment that she could have done anything. And that is that, she knew that the dog, the the other dog had passed away that day before, but I don't think even that, combined with just knowing that, oh, he's an active dog, he's more anxious than our other dog. We worked with a trainer and he got better. I just don't think all of those factors, I don't think they get there, because I don't think there's any particular incident that, if you look at it in isolation, so I don't think just the fact that a dog has had its ups and downs, if no particular incident indicates dangerousness or viciousness, then I don't think that combining them gets you over that hill.
Okay.
And I did want to bring up, because it was alluded to, that in Shermack's case that Mr. Buddenbaum referenced in his brief, which was the notion about what kind of testimony from a moving party can be used to support a summary judgment. That stands for a proposition when the facts are peculiarly within the knowledge of the moving party. I think in this case, when we have veterinary records, we have the animal control records, we have the testimony of the dog trainer, I don't think that case applies in this instance, because there is other corroborating evidence. I don't think the fact that she couldn't remember the name of the medication says anything about Ms. Jordan's credibility or believability. And so I do think, I think if that case applied in the dog bite context, then nobody could ever get a dog bite summary judgment, when we know from revealing that the decisions of this court and the Supreme Court that people do get summary judgment when the evidence shows that there wasn't evidence of a vicious propensity. So in this case, I don't think that necessarily comes into play.
You're relying on the Alfano case, and you talked about it a little bit just a second ago. Wasn't one of the things about Alfano that the court concentrated on, and I understand that was a Court of Appeals case, and we aren't necessarily bound by the decisions of our own court. We are bound by the Supreme Court. But in that case, they did distinguish between context where the dog is properly restrained versus where it's brought into public spaces. Can you talk about that for a second?
Well, certainly, and I do think it makes a difference, but I don't think it makes a difference necessarily for Ms. Jordan when she wasn't involved in the specific decision to bring Gus into a public place.
I understand you say she wasn't involved in the specific decision, but she still gave him authority to do this. She gave Jacob authority to act as she would with the dog.
Well, she not specifically take him to Rural King or not. He didn't feel the need to ask. They treated it as a family dog.
Well, but you seem to say that we should agree with the trial court just because she didn't give him specific authority to do it. The thing is that she gave him general authority to do whatever she would do with the dog, and she didn't say, don't take him to Rural King today, right?
No, but she didn't know that he was going to take him that day.
But she also testified that she wouldn't have said no.
Certainly, but I don't think that fact that relates to her knowledge as it pertains to a dangerous condition, nor does it put her on the hook for a breach of duty.
It just sounds like you kind of want to have your cake and eat it too. In that, she didn't know all this, and but she was responsible for the dog, but she didn't know all these other things. It just sounds like it's a little bit wiffle-waffy.
No, I think, and it goes back to where I started, which is that I do think she tried to be responsible with Gus, both in the way she adopted him and the way she took him to the vet, in the way that she tried to get him trained. And so, again, I don't think any of the facts that have been established in the case show a vicious propensity. It's not to say that she doesn't have responsibility for the dog, but ultimately there has to be both the knowledge of the vicious propensity and a breach of the duty of reasonable care. And so I think not being at Rural King, not to say that it's not her dog, but it sort of goes back to the Tucker v. Duke discussion that I don't think has come up much in this discussion. But if that case, there's not a strict liability set up for pit bulls under Indiana law as it exists today. Ultimately, holding Ms. Jordan responsible for what Gus did at Rural King when she wasn't there and didn't decide to take him there that day would be tantamount to establishing a strict liability standard for pit bulls.
So you use the term vicious propensity, or one of us did. I think the term is dangerous propensity, and there is a difference there. And there's no question that she was responsible by adopting a pit bull that might otherwise have been killed at the shelter. So that's an important thing, that she did adopt a dog.
Well, she adopted the dog and did her best with it, I think, as the record shows. But
Thank you, counsel. Mr. Buddenbaum, you have your 5 minutes for rebuttal.
Thank you. And I don't want to judge what I heard, but it sounds like we were talking about weighing different pieces of evidence, which, of course, my position is that's what a jury should do. But let me just talk about that for a minute. Let me first start with the issue about whether he had the authority to go there or not. Based upon that relationship, living in the same house, taking care of the dog, his relationship with the prior dog, all of those factors in my mind tell me that he had implied authority to take that dog. She had taken the dog to a setting. The behaviorist or dog trainer had taken the dog to a retail setting, maybe even to Rural King, if I remember correctly. But he had implied authority. And I think, implied authority is this sort of mixed question of fact and law, but I think there are some facts there that a jury could weigh. Did he really have implied authority? Second thing, the behaviorist versus the expert that we have hired. Our expert is a University of Pennsylvania trained veterinary doctor whose primary job with dogs was that she was the vet for special operators for the United States Army's special operators, the dogs that they use. She knows dogs, she knows dog behavior. That's versus a dog trainer or behaviorist, whatever Julie says. Julie Allen's a very nice person, excellent person. But I think that a jury gets to weigh that evidence as to whether they believe our expert versus Julie Allen, who says, well, the dog's reactive, but he's okay, he's not dangerous. Third thing, speaking of reactive ear, or reactive to when the ear is touched. I mean, in the Alfano case, the dog was sequestered behind a fence, and there was actually a warning sign that said, beware of dog. Kids would pet the dog. The second kid came, unfortunately, and was injured. There's no indication here that this dog was sequestered or that it came with a warning. All we have here is that it doesn't like to have its ear touched. There was some indication by some of the testimony, I don't know that it's direct, that in somehow my client patting the dog on its head is somehow the cause of why she got bit in the face. There's no warning to that. If there was any indication of that, which was clearly within the knowledge of this appellant, that she knew that the dog reacted to its ears being touched, then that would be another reason for it not to be taken to a social setting with strangers.
I was gonna say, doesn't that get down to her fault as far as what a jury would assign to her in the whole thing?
Yes. And I think and that's a great point. I think the jury has to assign fault between her and Jacob Grisham. I have little doubt that between the two of them, they're more than 50% at fault. And of course, in our comparative fault, we have to have at least 51%. And I think there's little doubt of that, but I think a jury gets to allocate that. We've all seen the verdict forms where that's done on the verdict forms. In terms of, and the demeanor of the witnesses, of course, is important. In terms of, credibility, and they live together, they have a social setting, as Mr. Mervaldi said, they have it's a family dog, we have a family situation there, and the credibility between these two people is important. Mr. Grisham, during his deposition, said, when I specifically asked him, did it knock her glasses off, he said no. He was emphatic it didn't knock the glasses off till I showed him the video showing that the glasses were knocked off. And then he also adds in the whole thing about and somehow she wasn't bit, that this actually wasn't a bite. So, all of that goes to credibility questions that I think a jury should hear. And for that reason, the appellant respectfully requests that this court, overturning the error made by the trial court, and set this matter so it should go back to a jury trial. Thank you.
Thank you, counsel. This concludes the formal part of our oral argument today. I would ask you to please take nothing from the questions that we ask. We ask questions to stimulate discussion. You had a great opportunity here today to see two very fine lawyers arguing their cases in front of what turned out to be kind of a hot bench as far as with questions. So we really kind of peppered you all, and we really thank you guys for driving out here to IU East to present this oral argument, in front of this audience. One of the things that we enjoy doing at these oral arguments is coming out from behind the bench and answering your questions. I do caution you, however, that we can't answer questions about this case. We haven't decided it yet. We will talk about it and issue an opinion in due course, which you will get, but we can't answer questions about this case. So to the extent you have a lot of dog questions, sorry, we can't do it today. Before we come out, I would like to thank a couple people. Thanks to Scott Lee, Kevin Hayden, Chancellor Rome, and the Office of External Affairs for hosting today's event. We really love coming out here. It's not too far from Indianapolis, and it's a great drive, and you guys are always so nice, and you have the best scones. So anyway, thank you. At this point in time, the formal part of the oral argument is concluded. We'll come out and answer some questions.
All rise. This court is now adjourned. You may be seated.